SJC-11904, Commonwealth v. David A. Coggeshall.
Good morning, Ms. Madge.
Good morning, Your Honors. May it please the Court, I represent the Commonwealth. I would like to start by saying that this case is not about the sufficiency of evidence. It's not about intoxication as a defense at trial. It's about a judge's authority to dismiss a case at the pre-trial stage where there was sufficient evidence contained in the materials submitted to the clerk magistrate for the reckless endangerment of a child charge. That statute, Chapter 265, Section 13L, defines reckless endangerment and penalizes anyone who engages in conduct that creates a substantial risk of serious bodily injury or sexual abuse to a child, and defines it in the statute as being aware of and consciously disregarding a substantial and unjustifiable risk that those acts would result in serious bodily injury or sexual abuse to a child. Therefore, the materials submitted to the clerk magistrate need to contain sufficient facts that there was a child under the age of 18, and I would submit to the court that that was clearly established in this case. The police report submitted established that the child was 11 years old at the time, and that they also have to show that there's a substantial risk of serious bodily injury. Here, I would again submit that there's sufficient facts alleged in the police report that there's walking on active train tracks, and I would submit to the court that that's established because the police report indicates the police actually had to reach out to the MPTA to slow a scheduled train en route to allow time for the individuals to get off the track. And then the last element is that that the defendant wantonly or recklessly engaged in this conduct that created the unjustifiable risk. And here I would suggest that that's also met, that we're at the probable cause stage. So what was in that police report that established that? One, we know that the defendant knew he was on...
Before you get there...
Yes, Your Honor.
What is the standard that you say defines wanton or reckless behavior? The statute in 13L says it occurs when a person is aware of and consciously disregards a substantial and justifiable risk. So do you agree that the statute requires that Mr. Coggeshall must have been shown to have probable cause, that he was aware and consciously disregarded that risk?
As defined in Figueroa, it's intentional conduct, and it says that someone could be knew or should have known.
Yeah, but how about the statute? Doesn't that trump the case law?
Your Honor, I would suggest that there's actually, this court has recently found in a 128 decision, Mark and Gallo, they actually found that in that particular case, citing the statute and also citing Figueroa and also citing Hendricks, that it was reasonable that the jury could have found that a reasonable person would have known that driving, speeding in the snowstorm, going through the red lights would have created the unjustifiable risk to the child. So I would suggest, in fact, that the statute standard of recklessness is not different from that defined in Figueroa or Hendricks. And in fact, the recent 128 decision illustrates that.
So when you want us to read, quote, wanton or reckless behavior occurs when a person is aware of and consciously disregards a substantial and unjustifiable risk, to mean wanton or reckless behavior occurs when a reasonable person is aware of and consciously disregards a substantial and justifiable risk. You want us to read the word reasonable into the statute?
To read, I believe that, yes, Your Honor, I would.
And how can we do that, especially for a criminal statute?
Intent. I believe that the case law, Your Honor, suggests that although the statute shows that a person needs to be aware of, they have interpreted it to mean as an objective standard, that a reasonable person should have known. And in this particular case, it is reasonable to infer that a person who always walks on the train tracks and knows that they are active because they always walk on those train tracks would know that it's a dangerous situation. And therefore,
so that's more than, I would say, that's more than what a reasonable person would know. I mean, you've got what was in the police report, that he did, I mean, I'm supporting your view, that this man would know because he did walk on the train tracks all the time, and as he said, he was fucked up. So it wasn't just that anybody reasonably would know, but he had actual experience on these train tracks, right?
Yes, Your Honor.
Actually, could I go back to that just to clarify on the fucked up? Excuse the language I'm quoting, obviously. Wasn't he alluding to, and didn't you argue below, although this wasn't developed, and again on appeal, that what he was alluding to was the fact that he was highly intoxicated. In fact, he was so intoxicated that the 11-year-old had to pick him up off the rail, or fell down. So you don't expand much on this, but I understood you to be suggesting here that what we have, in fact, is an individual who knew when he went to the bar and got really drunk and knew he was going to walk on the railroad tracks. Those are the kinds of endangerment that he was exposing the 11-year-old child to. Not, you begin with going to the bar and getting drunk to the point where he can't walk, and then taking an 11-year-old and walking down a live track at 2 in the middle of the day. It's not at night. I mean, it's different in the middle of the day. They're not both conscious. In fact, he's not conscious. I thought that was your argument.
Your Honor, my argument is that walking on train tracks that he knew to be active with his 11-year-old son was reckless, and that it exposed his 11-year-old. So you're
abandoning the argument that being really drunk and then taking his child on a railroad track where he knew he was going to go, that didn't encompass the highly intoxicated, instead of being a defense, was part of the reckless endangerment, as it is in several other states. So you're saying that's no longer going to be your argument? That's
not, it is still part of my argument. However, it is not the crux of the argument. Even if the defendant was not intoxicated, walking upon those active train tracks would still create a reckless risk for his 11-year-old son. Being intoxicated so much so that his son would have to help him get off the tracks if a track was coming and carrying some bags only aggravates the recklessness and the dangerousness of the situation, Your Honor.
Does statutory history help us at all with what the legislature had in mind when they defined the terms the way that they did, which is not the same as it appears in the cases in our common law?
The legislative history, it appears that, reading the preamble to the statute, that it was developed to protect those against substantial physical or sexual abuse, so it was against abuse. However, that has been expanded.
So that was, the legislative history suggests it was adopted in order to combat instances where adults knowingly, with all awareness, put children in danger by virtue of sexual or physical abuse.
Yes, however, case law has indicated.
Well, but what does that tell you about legislative intent, not about what cases say?
Yes, but however, the court has interpreted it, is that it was not meant to only combat that. That if
the language itself is not limited in that respect.
Yes, Your Honor. Thank you. And that it was meant that was one part of it, but that preventing or penalizing any behavior that creates a substantial risk of serious bodily injury is what the statute is meant to do, and that's not in opposition to that, Your Honor.
Mm-hmm. Well, that's a huge, I mean, in the context of, say, priestly sexual abuse, that's a huge difference, isn't it? I mean, between a priest knowing that, or a bishop knowing that a priest is involved in sexual abuse versus saying that he reasonably should have been aware of it. I mean, that would be a huge difference in terms of the culpability of, say, a bishop or somebody for the conduct of a priest involved in sexual abuse. I mean, if that was the context of the statute, wouldn't it make sense, or at least be reasonable, to expect that the legislature would have meant what it said?
In a particular case, yes, it was, when speaking of physical abuse or sexual abuse in the context of the priests, yes, it would be required that you had actual knowledge of that or should have had knowledge. You couldn't turn a blind eye to it. But in this particular case, walking on active train tracks with a child is common knowledge. Average everyday people know you do not walk on active train tracks, especially with children. And this particular defendant actually knew that those train tracks were active because by his own admission, he had been on them before.
Right, but that goes to your point that even if it is a subjective standard, you should still win.
Yes, Your Honor.
It doesn't go to the issue of whether it's a subjective versus an objective standard. Your view is that You say it's objective or subjective, but even if it is purely subjective, you should still win because there was probable cause to believe this defendant knew of that risk.
Yes, and I believe reading the recent case law by this court was that a reasonable person, a little bit of an objective standard, is now part of this or is viewed as part of it, as Mark Angelo was speaking about. In Hendricks, the case was about the individual fleeing with the child in his car. And he actually, this is again a sufficiency of evidence standard where we are not at. We are at a probable cause standard. However, for argument's sake, going to that, in that case, the defendant actually made an admission that he shouldn't have been doing that with his child. However, that's not the case in Mark Angelo. In Mark Angelo, the court found that a reasonable jury could infer that it was reckless for the person to be driving the snowy conditions through the red lights with a young child in the car. So in that case, the defendant, there was no admission. However, the court found that it was reasonable. So a reasonable person would have known that you don't do that. So I argue that in my particular case, that there is probable cause about subjective knowledge. The defendant had walked on those train tracks before.
What about the fact that he was very drunk? Does that have any effect on his knowledge of the danger?
That is one factor that can be considered at trial at the sufficiency of the evidence stage. However, this case was only at the probable cause stage.
You can't consider that in assessing probable cause?
Intoxication, I would suggest, Your Honor, it does not negate probable cause. And there are other factors that indicated that he knew what was going on. He knew he was on the tracks. The officer asked, "What are you doing on the tracks?" "I always walk on the tracks." He offered the information that he was, excuse my language, fucked up. He even responded, "Oh, how much did you have to drink?" "A few beers." So he's able to respond appropriately, in a sense, to what is going on. So there is ample probable cause that he knew what was going on. And I would suggest that intoxication is one factor to consider at defense at the trial stage, at the fact finder stage, not at the probable cause stage.
Or as Justice Duffley suggested, maybe even an aggravated form of the offense.
Yes.
To actually get drunk, walk on the tracks with your child, knowing that these are live tracks, is a double problem.
Yes, I would agree with that.
There is an objective standard, and that is that the reasonable person would understand, as you alluded to. You don't walk on a railroad track, but a lot of people do. And the ones that are in trouble are the ones that have earphones on, aren't paying attention, not middle of the day, sunny day, no other indicators of. So it's an 11-year-old, not a 2-year-old. It's an 11-year-old who can hear, no indicators, there's something on. Why, objectively, does every person who's trespassing on railroad tracks in broad daylight with no other impediments to seeing, hearing, appreciating noise and potential danger, why does that pose a risk?
Trains travel very quickly, and in this particular case, the 11-year-old is trying to hold up his father. It's reasonable to assume he would try to get his father off the tracks, so he would be responsible for carrying those bags that are on his back and getting his father and himself.
So now you're including let's take the intoxication out, as you suggested might be appropriate. Forget about intoxication, except as a defense. Somebody walking down a railroad track, an 11-year-old who can jump off the track because they're not listening to music. Is that a reasonable person? The judge was not entitled to view that as something a reasonable person might not say poses, and it's a pretty high standard of a degree of danger, not just a possible or not just negligence, right?
Yes. Again, I would submit to the court that trains are very fast and very dangerous, and that's why they're blocked off. So cars which travel quickly aren't even supposed to cross on roadways. Trains travel very quickly and pose a very serious risk. If you were hit by a train, there's serious bodily injury or death is almost certain. If that type of danger wasn't recognized by our society, then there wouldn't be those blocks that you can't walk on train tracks. Those signs would not come down.
Those are because you don't know one's coming if you're in a car crossing. But the statute doesn't suggest that. The statute just says trespass, at least with respect to walking on road. It doesn't, right? It's a trespass. Mm-hmm. So you're saying that in all cases, anytime you're on a railroad track with a child of any age under the age of 18, no matter what the circumstances, you have just objectively, that's a risk that if you knew about it, well, not if you knew about it, right, you take your child there, that's going to result.
I'm sure there could be
in
some situations where you're doing the lesser of two evils and you need to take your child on the train tracks.
Not that.
But however, this particular case, they're walking along the train tracks. They're not simply trying to cross the train tracks. The police report establishes that they're in Hanson, I believe, and then come over to Halifax, and that the officers on the other side can see them. So they're traveling for a period of time on the train tracks. And I would suggest that, yes, it is almost always too dangerous to have your child walking along active train tracks when a train is coming. And yes, maybe you will be able to run and get off it, but the kid has bags. You don't know whatever else is along that side of it. It could just be all woods. It's a very dangerous situation. I would suggest that yes.
Okay, thank you.
Thank you very much.
Good morning. May it please the court. Tara Ganguly on behalf of David Coggeshall. I would just like to start with something that Justice Duffley actually mentioned in an exchange with my sister about intoxication. He's not conscious. The statute specifically says that a defendant must be aware and consciously disregard. If he's not conscious because—
Well, he's certainly conscious. He answered questions. He was questioned by the police, so he's not unconscious.
He's not unconscious as in sleeping, but
He's aware he's on the tracks. He's aware he's had too much to drink. He's aware he's with his son, right?
Correct. But I believe that rises to a level of negligence. I don't think it rises to a level of recklessness as the statute defines it.
So your view...
Reckless you can be, the more reckless you are, the less reckless you are? I mean, the drunker you get?
No, I think there's a difference between this case and a case of drunk driving with a child in the car.
Because?
Because that person would have to take many more intentional, affirmative steps to engage in that conduct.
At a probable cause state of events?
Even at the probable cause stage, the police report, you have to engage in a certain speculative leap, even to meet probable cause in this case. Yes, he's aware he's on the tracks. He specifically says, I always walk on the tracks. His 11-year-old son is with him. Again, this is not a 3-year-old. The son is the one holding his father's hand. The son is the one following his father, helping his father. It's not a perfect, great situation, but it is different than if it was a much younger child.
So you say there was no probable cause to arrest?
I don't believe there was probable cause to arrest. And
So officer, this happens again under exactly the same circumstances. Officer stops and questions him. He says all that he said, that he's unbelievably drunk. And the officer is supposed to say, golly, you are so intoxicated that I can't be sure that you're reckless, so I'm going to just walk away and let you continue to walk down the tracks because I don't have probable cause to arrest?
Well, if we're going by the law, which is the four corners of the complaint encompassing the police report, this police report, maybe there were additional questions asked and those facts weren't put in a police report. This police report only indicates his level of intoxication, that he was extremely intoxicated, that his son was with him, his son was holding him up, he fell down, his son was trying to help him. There's just not enough there for awareness and
So I'm just trying to be clear. Your position here is that in this case, this police officer, after having questioned this defendant, or this person, he was not yet a defendant, should have walked away and not arrested him.
Arrested him for trespassing on the tracks, which he did.
Okay, so you're saying the arrest would be appropriate, but only for trespassing?
Correct. And I believe the statutory language is extremely clear, but even going beyond that, as discussed with my sister, the legislative intent of this statute is very clear. And going back to one point that my sister mentioned in the context of the Catholic Church abuse scandal, it's not that priests should have had whether a priest should have had knowledge that a child was going to be abused. It's whether the priest did have knowledge that the child was going to be abused.
So if you had a priest who did have knowledge but was so drunk that he forgot it, he doesn't get charged? At the time that the, or...
Well, in that context, the decision-making process would be so different. It wasn't, that's not a discrete...
Just this follows up on Chief Justice Gantz's question. Let's say we're not on the train tracks on which a trespass charge will, but it's the side of the road, a highway. It's not trespassing. But you're walking on 95 along with your son, completely drunk, right at the edge of the shoulder. So it's really, really dangerous. Police come along, no complaint because the person's so drunk?
I think
and you just let him go?
No, I actually think that would be, that, depending on the facts, most likely would meet the probable cause standard, at least. In this case, and it goes to the second issue in my brief, the substantiality of the risk is different walking on the train tracks than it is walking on a busy highway like 95. Walking on a train tracks, it is a crime. It's a fine only. The legislature doesn't believe that it even encompasses...
The risk is you're going to get slammed with a train and die right there. I mean, what's I don't see the difference in the risk.
It's the likelihood of that happening. We don't know where, we don't know exactly where the train was. This was an 11-year-old. It wasn't a substantial risk that he was going to be struck by the train. It was a possibility.
So if his father fell down drunk as the train was approaching, it's not likely that the kid was going to try to help his father get off the tracks and his father was just dead weight at that time?
It's likely that he would have helped him get off the tracks, but I still don't think that it rises to the level of a substantial risk.
Now, the statute says the risk must be of such nature and degree that disregard of the risk constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Don't you think a reasonable person would say, don't walk on the train tracks alone, let alone with a child?
Perhaps, but
perhaps.
There is.
I mean, unless you know it's an abandoned train track, but there's no suggestion of anything like that, right?
Correct. So, but even if a reasonable person believes that doesn't.
This is what the statute says defines the risk.
Right, but that's the second clause of that section. There still has to be awareness and conscious disregard.
I understand that, but I'm saying that when you're talking about you're trying to measure out different kinds of risks, and I'm saying here that I think the statute tells us that the risk has to be such that, disregarding it would constitute a gross deviation from the standard of conduct that a reasonable person would observe in the situation. I think you're hard-pressed to say that a reasonable person would not say, don't walk on the train tracks.
Yes, but a reasonable person would also say, I don't think, and I realize this is a Superior Court case, but there was a case cited in my brief, Hernandez, where the judge didn't believe that kids being in the presence in an apartment where drug packaging was being done and the kids being around that judge didn't believe that rose to the level of a substantial risk. A reasonable person might say, of course, don't do that, that's a risk. But the reasonable person goes to the knowledge of the risk, not the probability or likelihood of something bad actually happening. If there are no further questions, I'll rest on my brief.
Okay, thank you.
Thank you.